Something unusual and frankly controversial just happened in court today. The state prosecutor advocate Baloyi hands over a crucial police occurrence book directly to the accused, which is Bongani Ntanzi. But here is the problem. His own lawyer, advocate Ramasepele, had never seen that document. And what happens next? A courtroom interruption, a legal objection, and a serious question about whether proper procedure was followed by Mr. Baloyi. Because in South Africa, this is not just about documents. It's about fair trial rights. Let's break it down clearly. In an open court, the state introduces an occurrence book from Moot police station. Instead of first showing it to the defense, advocate Baloyi hands it directly to Ntanzi. Immediately, advocate Ramasepele stands up and objects. His message is, this is not how things are done. And he's not just being difficult. There is a legal foundation behind that objection. Before we get to it, let's watch this clip first.
My Lord, I'm here before court. Every morning I say, my Lord, I confirm that I represent Mr. Ntanzi. This procedure now that is happening here, that Advocate Baloyi takes an original of an occurrence book from Moot and hands it to Mr. Ntanzi to confirm something without me having taken instructions. I've never heard of that procedure before.
Yeah, maybe you should show you that the person who requested that was Mr. Ntanzi himself. But you've got to show it's also to Mr. Ramasepele.
Yes, but Mr. Ntanzi is under cross-examination.
Yeah, I know that.
Mr. Ramasepele cannot take instructions.
We know that, but just show you so
I don't
that you get through this.
Can we then take the normal sugar?
Yeah,
In South Africa, this situation goes straight to the Constitution. Section 35 of the Constitution guarantees the right to a fair trial, the right to legal representation, the right to adequate time and facilities to prepare a defense. And here is the key part many people miss. Legal representation is not just about having a lawyer sitting next to you. It means your lawyer must be involved in each and every piece of evidence. Your lawyer must prepare you before you respond. Because under the South African law, the accused must be able to challenge evidence, consult with their lawyer before engaging with it. Now let's decode the frustrations from Ramasepele. He basically told the court, I represent this man every day, but now evidence is being shown without me. I have not taken instructions. That last line is critical. Taking instructions means consulting with your client, preparing them for what they are about to see or say. If that doesn't happen, the defense is blindsided, and in legal terms that can lead to prejudice against the accused, a potentially unfair trial. Now let's bring in the law. Criminal Procedure Act 51 of 1977, South Africa. This law governs how criminal trials are conducted. The key principle is evidence must be presented in a way that is fair and transparent. The Act reinforces that the accused has a right to legal assistance during proceedings. The defense must have an opportunity to challenge and respond to evidence. And importantly, the law of evidence in South Africa also requires that evidence must not be obtained or presented in a way that undermines fairness. If it does, it can be challenged or even excluded. But in this specific case of the Senzo Miyameda trial, I don't think that's going to happen under RAT. We already know. It's been years. Now, let's be fair to the state. Advocate Baloyi says Ntanzi requested to see the occurrence book. It sounds reasonable, right? But legally, that's not enough. Because even if the accused was demanding it, the process still matters. Why? Because the accused may not fully understand the implications. The lawyer must guide how that evidence is approached. This is exactly why courts emphasizes the right to consult before engaging with evidence. This moment reveals something deeper, a tension we keep seeing in this trial. Speed versus fairness. On one side, the state pushing forward, and the other, which is the defense, saying slow down and follow the procedure. If shortcuts are allowed, it's risking violating Section 35 fair trial right. And in the South African law, evidence obtained unfairly can be excluded if it makes the trial unfair, brings the justice system into disrepute. Oh, did I spell that right? The judge doesn't fully shut it down. Instead, there is a sense of let's proceed that raises questions. Is the court allowing flexibility or overlooking a procedural issue? Because once you allow one exception, where does it stop? This is why cases like this matter. It's not just for the accused, but it's for how justice is carried out in South Africa. So now I want to hear from you. Was Advocate Ramasepele right to object? Was the state justified? Drop your thoughts in the comment section, and don't forget to follow the Hot Series Say on Facebook. We are just getting started there, and we are bringing you even more real-time news and courtroom breakdowns. This is the Hot Series A, where we just don't report the news, we expose what's really happening inside the courtroom. Hola.
The third call, it's an outgoing call from the number of accused number 10137 on the 5th of January 2019 at 10:13:51. It's an outgoing call, an MOC lasting 22 seconds to your number ending 6890.
Yebo, lena okhuluma ngayo wena ke i-call lena eyesithathu ke ngazo i-5 kuJanuary 2019 isikhathi u-10:13:51. I-call eyayibuya kwinamba yakhe umsolo waqala u-0137 iya kweyakho inamba u-6890 eyathatha ama-seconds awu-22.
Ye ongenza mhlawumbe ngoba namanamba edibene so khona lokho mhlawumbe ngangufuna or bona babekufuna kungenzeka.
It is possible, as I am now looking at these numbers, that there's something that I wanted or there's something that they wanted. That's possible.
And again on the 5th of January 2019, 10:17:40 seconds, your number ending 6890 makes a call to the number of accused number 1 ending 0137, lasting 16 seconds. The tower remains 2G Kohlokolo.
Phinde futhi ke ngazo i-5 kuJanuary 2019 isikhathi u-10:17 nama-seconds awu-40. Inamba yakho egcina ngo-6890 yashayela-ke inamba yakhe umsolo wokuqala egcina ngo-0137 ama-seconds awu-16 nalapho itower kuseyona-ke Kohlokolo.
Welcome to the fire where the stakes ignite, where the questions burn hotter than the night. No escape once you're locked in the heat. This is your trial.